And now we shift focus and discuss our conversation is succession matters. Have you ever thought about who is going to inherit you once you pass on? Have you ever even put a thought to writing a will and why you need it? So tonight on Sunday Express, we are joined by none other than Njomo, Wakili Njomo John, an advocate of the High Court, to take us through this conversation. Thank you, sir, for making time.
Thank you, Regina.
Now, we start off with the most common, legal challenges that face during this particular succession process in Kenya. In your time that you have been practicing this, maybe just unpack that so that then we can go through them.
Oh, thank you. Thank you very much. And, succession process occurs where every time there's a death, someone dies, you cannot deal with the person's property until you conduct the process of succession. Mm-hmm. So that the requirement is that you have to go to court and then start the process of explaining that someone has died and he or she left the following properties, which then should be administered through the succession process. So that sometimes people don't have much of information as to what needs to be done, because there are basic things that you have to follow for the process to be successful. And one of the things, because of lack of information, sometimes if you leave out a property that belongs to the deceased person and it is not included in the succession process, then you start facing hurdles. So there's a problem of either leaving properties outside the succession process or leaving out some beneficiaries. The people who benefit or who are supposed to get an interest in what the deceased person left are called beneficiaries. So that if you leave out a beneficiary from that process, again, you have a problem, because whatever you get from the court can be nullified, and then you end up with repeating the entire process all over again. So people face such challenges, and it is important for, first of all, to sit down as a family of this deceased person and agree that these are the people who are supposed to benefit from we call it the estate. You list them, number 1, 2, 3, and 4. And then you also say that these are the properties that are left behind, so that you are very clear from the word go as to who is to benefit and what the properties to be shared out. Yeah.
So that it needs a collective, a collective agreement, for those who are supposed to benefit or other members of the deceased.
That is very correct, Regina, because we actually encourage people to take their time, sit down as a family and agree on those particular 2 issues. Okay. Who are the beneficiaries and who are the properties to be shared out.
So what happens if they said the deceased had not disclosed the extent of his estate? That's one. And secondly, they had not also disclosed that there were others who are likely to benefit. Maybe they had a family that the other family did not know about. What happens in that case?
You get it right, because sometimes people manage their properties in a secretive manner, that you have land here, you have land there, but you don't want your family members to know, because sometimes people don't contemplate that their end is coming, and no one is sure about tomorrow. We don't know how long we are to live. So that if that happens and someone dies and the family is not aware that properties belonged to him, then you find a situation where the family members might actually leave out those properties from the administration through succession. And that is why there's an agency that has come to the fore called the Unclaimed Financial Assets Authority, so that they can try and collect some of these things. Some of the things that people leave out are bank accounts. People don't know how many bank accounts someone is holding. You have shares in companies. You have not disclosed that you have investment in such companies. So people are not aware.
Even on M-Pesa, e-wallets.
E-wallets, M-Pesa is left out. All these kind of assets, sometimes people assume that you'll have a chance to disclose to your family members that this is what belongs to you, but then death comes and then they are left in the dark.
All right. So, other than just not being a lack of information of what is out there in terms of the estate, the nexus, or rather the challenges between culture and tradition, that impede on this legal process.
Yes, we have faced that. Because for a very long time, there was a misconception as to who is to inherit properties. People have been saying that since the 2010 Constitution, women are now allowed to inherit properties. But that is a misconception. It's only that it is strengthened what was there before in what is called the Law of Succession Act. Because even the Law of Succession Act that has been there for many years still provided that people are supposed to inherit properties, men and women. But then come 2010 Constitution, we have a situation where it provides very expressly that you should not discriminate against any person because of the reasons, for instance, gender. That you cannot say that the properties belonging to someone who has died will not be shared to his daughters, for instance, yes, because they are women. That has been strengthened by the provision of the Constitution that provides that people should not be discriminated against. But then you have the issue of culture that says sometimes within this particular community, properties are only shared to men. But then the Constitution comes and says that customs which are retrogressive in nature or laws that are against the Constitution itself or any other written law should not have a force of legal effect. So that if you have a cultural belief or customary practice that then discriminates against women and ladies, then that particular culture practice cannot be tolerated within the Law Succession Act. But we have a situation where women find themselves in those situations. And what we have been telling them is that the law provides and protects all of them. All of them. So that in terms of legal protection, the law has proper safeguards to ensure that everyone benefits. But in terms of practice, people are maybe not willing to speak out. If you are told that it is a taboo for you to follow up on your maybe your deceased father's property, you feel like you don't want to follow that because people believe that probably you might inherit a curse or something like that.
Yes.
Because those cultural practices, when you compare them or you put them, you juxtapose them with the actual practice on the ground, yes, things could be different.
Things could be different.
The law provides actually safeguards to ensure that everyone is treated equally.
So from what you're saying, Wakili, is that as per the Constitution 2020, it reaffirmed the law's provision for women as well as children in as far as
all equals to inherit property. Equally, both men and female. Okay. They have equal rights.
Now we find ourselves in a different dispensation in the 21st century. Young people, is there room for them when it comes to succession matters, you see? Are we seeing, fathers sitting down with their sons and daughters and having this conversation?
I think with information and the advent of information that people are now more enlightened, we are finding a situation where people are embracing what we can call estate planning in a way that you could say family are now disclosing. It is known. Most of the people are probably not hiding their properties. It is known that this is what I own, this is what I owe, because you're supposed to know the properties that you have and also the liabilities that's supposed to be sorted out when you meet your maker. But then we have a situation where people are now embracing even new trends, things like called trust, that you have all your properties collected in a given entity so that in case of demise, that continues to exist even after the owner's death. So that we have now situations where the situation is changing and people are embracing new ways of managing their properties through wills, maybe. Because for a long time, we could mention that the statistics that we have are that we have about 20% of people making wills. It is not something that has been embraced by many people because people think that the moment you do a will, probably you're about to die.
You're inviting death to your door.
It's something you can do. You populate it with time. You have more properties after 5 years. You're still alive because you're still working. You can continue increasing and adding properties that you own in the will. It doesn't mean that at the moment you do a will, you are going to die the following day or soon thereafter.
Is there a right time to start writing a will?
I think the right time to write a will is anytime you have a property. If you have something...
Once you acquire it, you note it down.
Again, you can't do a will if you don't own anything, because a will is supposed to give properties to the future generations or people who will outlive the maker of the will, who is called a testator. So that if you have property, it doesn't do any harm to have a will, even if it is one, so that you have control. What we say is that through a will, someone is able to speak and guide the process even after death. Because if you don't do a will, then the process of administering your estates is very different as to whether you have a will. Because if you have a will, your wishes are known, and that is what will be followed. If you don't have a will, then that process is called intestate succession, and the law takes into effect, so that you don't have control as to who you should give and who is to benefit from your properties.
All right.
So that is when the will comes in.
You mentioned inheritance as well as liability, and when I look at liability, I'm looking at debt posthumous. What happens in the event that the deceased, had debt? How do we handle that?
There are different scenarios. So there are debts that are secured, that are will not outlive the life of the borrower. So that if you maybe take a loan or a mortgage, you could have an insurance that is life insurance, that is covered. But there are some, if I borrow you some money and I give me 1 million shillings, and it is known, you have a document that I owe, you owe me, or I owe you, then that situation is, that is not a secured kind of loan, and it is not insured.
Also,
so that
personal
even
loans,
after
I
the
believe.
personal loans, that is the example that I'm giving, those personal loans will follow. Anyone who has lent someone has the right to follow that money in case there is no insurance to secure the lender in case of demise.
In case of demise. Now, there comes in the intermediaries, and this is where wakili, lawyers, and, they come in. The issue of trust. The issue of trust, because we've had cases where now also lawyers are being crafty and disinheriting the beneficiaries of the estate.
It will be a very unfortunate incident, and which then borders on professional misconduct, because an advocate-client relationship is one of trust, 100% trust, that the moment someone comes and tells me that I have done a will, which is supposed to be known to my beneficiaries after my death, I should be able to keep that as a professional. But in a situation where then that professional is taking advantage, action can be taken against, because you're not allowed to intermeddle with that particular process. So that, but then it happens sometimes that you find professionals who are taking advantage and then even getting conflicted. Because the moment you have been left by someone the trust to manage the estate, and then again, you also have your own interest as to how you are going to get your hand in it. That is misconduct, and action can be taken against through the professional ethics process. That the family can claim against that particular advocate through the Advocates Complaint Commission and say that Advocate X is mishandling our estate, and we are not happy with the way things are being done. And or rather, the family is also allowed to change an advocate. If you realize that your advocate is not doing the right thing, is not discharging his or her duties professionally, you're allowed to change that advocate and appoint another person to do that process for you.
All right.
Yeah.
Situations where we have seen families actually get into a dispute, succession matters, yet there's a will. What situations, guarantee or rather necessitate this kind of situation?
A proper process where a will has been written, it is important to ensure that the legal steps are followed. One of the things that we have been advising people is to ensure that the document is very explanatory as to the legal or mental capacity of the person who is making the will. Because it should be very clear that that person is of sound mind and understands what he's doing. So that a will is tested through the court process. A will can be invalidated in case it doesn't meet some legal threshold requirements. So that when you're making it, you should be very, very keen on the things that you are doing. One of the things that you should disclose is the people who are supposed to benefit from your properties. Even if you don't want to give maybe one of your children some properties that you have, it should be very clear in the will that you know you have that particular child, but you have decided not to give property to him or her. But a situation where the will does not disclose all your beneficiaries, then that particular person who has been left out can go to court and say that this person did not understand what he or she was doing, and that will can be invalidated. Again, one of the things we also advise is as to witnesses, because a will should be witnessed by someone who is not benefiting again. You cannot appoint or give me a property within the will, and I also act as a witness. So those small mishaps sometimes mess up a very critical document that's supposed to guide your affairs after death. So it is very important to prepare properly and also seek legal advice sometimes when you're doing such documentation. Okay.
Now, we have been discussing succession matters, and we are going to have this conversation once again, given the number of questions that you're getting on our social media platforms. There's a Karaoke there who is saying that this is a very good, informative conversation. And thank you very much for that feedback. We're going to be looking at, your feedback and sharing it with our guest tonight, who's none other than Wakili Njomo John, or an advocate of the High Court with Kamotho and Njomo advocates there, just giving insights on the trends in as far as matters succession is concerned, the do's and don'ts. And this is a conversation we're going to have once again, as given the emerging trends that we've seen. We've seen a High Court ruling there that has pitted the religion, seemingly pitting religion against the Constitution 2010. So we bring this conversation to a close. Be sure to check our website for further details. But before we call it a day or a night, I hand you over to John Jacob Curie on the other side of the studio with an update on what is happening in the sporting